I have covered the topic of Section 3C leave under the Immigration Act 1971. This applies where a person submits an in-country application to extend or vary their leave, and providing that that application is made on or before the date of expiry of their leave, they will be able to reside in the country until such time as a decision is received on their application or all appeal rights are exhausted, and that is known as Section 3C leave. That has not changed. The law will remain in place that when you submit an application, you're not left in limbo because your leave had officially come to an end, but you have not yet received a decision. What has been clarified has resulted from a recent case. In summary, the court was asked to decide whether it was lawful for the Secretary of State or the Home Office to fail to provide applicants with documents confirming that they had an outstanding application. So for instance, a person leave to remain in the country may end on the 1st of June, and therefore their biometric residence permit or online status would have an end date of the 1st of June 2024. When they try to demonstrate to their employer that actually their leave continued automatically under Section 3C leave, the employer had no documents to confirm this. Instead, the employer is expected to contact the business help desk as a part of the Home Office to confirm a person's ability to continue working in the UK. But given the immigration landscape at the moment, many employers are very hesitant to do so. Previously, the Home Office would have provided a letter to the applicant confirming that they had submitted an application. The application is with the Home Office and the person has Section 3C leave until such time as a decision is made or all appeal rights are exhausted. But as the system has now moved to a more online system of proving a person's status, there was a gap whereby a person would submit an application and there was nothing online to show that they continued to have a right of residence. And so this case sought to challenge that. The High Court agreed and stated that the Secretary of State had acted unlawfully by not providing some sort of confirmation, whether digitally or otherwise, that the person had an ongoing right of residence in the UK under Section 3C of the Immigration Act 1971. And therefore, the Home Office is now expected to provide some sort of online record. So by having that online proof, it allows the applicant to have a surety that they are able to prove to employers in particular their right to continue working and living in the UK, and therefore employers are also given that assurance that they are not acting unlawfully by continuing to hire the person or employ the person. So this is quite an important case because it clarifies that if an individual submits an application and has continued rights of residence and work in the UK, they will be expected to have some sort of ability to prove that by way of online documentation. So that's where this case stands at the moment. So if you are hearing a lot of information about Section 3C leave, that is the summary of where we are at the moment. I hope this content is of help. If it is, please let me know in the comments, and please share with anyone that needs to know this information and follow.